Dumelang, greetings, Ninjani, how are you? I'm well, I'm surviving. Getting there. The flu's getting better, it's getting better, guys. Okay, guys, with this video is to deal with the part 6 of the CCMA rules, the new rules that were released in April 2023, which is this year. In the last video, we dealt with part 5, so now we're going to be dealing with part 6. Okay, thank you very much, guys, for watching. Thank you very much for subscribing to the channel, and please continue supporting the channel. Please share the video. Please share the videos into different platforms that we are using. Encourage others to watch the channel, to subscribe. Let's grow the channel together, guys. Thank you very much. And the benefits of subscribing is that whenever I release a new video, then we get notified. We get notified. And now, because the power is back now, the power has been restored here in Maltapufu, because we've been without power for almost 3 weeks. So now I'm going back to the normal schedule of publishing the videos. I publish videos on Wednesdays and Saturdays. Okay, guys. All right, let's get to part 6, applications. How to bring an application. This rule applies to any application, including but not limited to A, condonation, joinder, substitution, variation, rescission, postponement, and disclosure of documents. B, application in a jurisdictional dispute. And C, other preliminary or interlocutory applications, right? 2, subject to Rule 32, an application must be brought at least 14 days prior to the date of the hearing on notice to all persons who have an interest in the application. 3, the party bringing the application must sign the notice of application in accordance with Rule 4 and must state A, the title of the matter, B, the case number assigned to the matter by the commission if available, C, the relief sought, D, the address at which the party delivering the document will accept delivery of all documents in the proceedings. E, that any party that intends to oppose the matter must deliver a notice of opposition and answering written statement or affidavit within 5 days after the application has been delivered to it. F, that the application may be heard in the absence of a party that does not comply with subparagraph E, and G, that a schedule is included listing the documents that are material and relevant to the application. Number 4, the application must be supported by a written statement or affidavit. The written statement or affidavit must clearly and concisely set out A, the names, descriptions, and addresses of the parties. B, a statement of the material facts in chronological order on which the application is based in sufficient details to enable any person opposing the application to reply to the facts. C, the statement of legal issues that arises from the material facts in sufficient details to enable any party to reply to the document. D, if the application is filed outside the relevant time period, grounds for condonation in accordance with Rule 9. And E, if the application is brought urgently, the circumstances why the matter is urgent and the reasons why it cannot be dealt with in accordance with the time frame prescribed in these rules. 5. A, any party opposing the application may deliver a notice of opposition and an answering written statement or affidavit within 5 days from the day on which the application was served on that party. B, a notice of opposition and answering written statement or affidavit must contain, with the changes required by the context, the information required by the sub-rule 3 and 4 respectively. Number 6A, the party initiating the proceedings may deliver a replying written statement or affidavit within 3 days from the day on which any notice of opposition and answering written statement or affidavit are served on it. B, the replying written statement or affidavit must address only issues raised in the answering written statement or affidavit and may not introduce new issues of fact or law. Number 7, in urgent application, the commission or commissioner may dispense with the requirements of this rule, and B, may only grant an order against a party that has had reasonable notice of application. B, applications may set down for a hearing or determined on the papers. Where the application is set down for hearing, the Commission must allocate a date for the hearing once a reply and written statement or affidavit is delivered, or once the time limit for delivering a reply and written statement or affidavit has lapsed, whichever occurs first. The Commission must notify the parties of the date, time, and place of the hearing of the application. 10. Despite this rule, the Commission or Commissioner may determine an application in any manner it deems fit, provided that the Commission or the Commissioner informs the parties of how the processes will be conducted and gives the parties an opportunity to be heard. 31A. How to apply for urgent picketing rules or the determination of disputes relating thereto. 1. This rule applies A. Applications for picketing rules in terms of the section 69(6)(b) of the Act. B. Disputes relating to the application or interpretation of picketing agreements or picketing rules determined by the Commissioner. And C. Disputes relating to an issue concerning picketing contemplated by section 69(8) of the Act. Number 2. An application must be brought in a prescribed form with supporting documentation. 3. The application must be served on all relevant parties. 4. Unless the two parties agree otherwise, the Commission must set down the application within 2 days of receipt of the application. 31B. How to apply for the enforcement of written undertakings or compliance orders. 1. This rule applies to any application for an undertaking to be made on arbitration award in terms of Section 68 subsection 3 of the Basic Conditions of Employment Act, and B. Application for the compliance order to be made an arbitration award in terms of Section 73 subsection 1 of the Basic Conditions of Employment Act. Number 2. An application must be brought in a prescribed form to which the following document must be attached. A. A copy of the undertaking or compliance order. B. In the case of a compliance order, prove that the compliance order was served on the employer in accordance with the Basic Conditions of Employment Act. C. Any documents related to the securing and undertaking of issuing of a compliance order, including a compliant or grievance and inspection report or other notes made during an inspection, and any relevant records of the employer. An inspection confirmatory affidavit if the inspector is not the one signing the prescribed form. E. Supporting witness or third-party affidavit where applicable. F. Any other relevant documents. 3. The application must be signed and commissioned by the referring party and served on all persons who have an interest in the matter, including the employer and the employee. 4. An employer may, subject to the provisions of the Basic Conditions of Employment Act, object to a written undertaking or compliance order being made an arbitration award by serving and filing an affidavit setting out its objections in accordance with the provisions of this rule. 5. An objection affidavit in terms of Sub-Rule 4 must be delivered supported by relevant documents to the Department of Employment and Labor and any affected employees and filed with the Commission within 5 days from the date on which the application was served on the employer. 6. The party initiating the proceedings may deliver a reply within 3 days from the day on which any objection is served on it. Number 4. The reply must address only issues raised in the objection affidavit contemplated in Sub-Rule 4 and may not introduce new issues of facts or law. 8. The Commission must, once a reply is delivered or the time limit for delivering a reply has lapsed, whichever occurs first, appoint a commissioner to determine the application by considering the documents filed in terms of this rule. Number 9. Despite Sub-Rule 7, the Commissioner may, if appropriate, request allocation of a hearing date, in which event the Commission must notify the parties of the date, time, and place of the hearing of the application. Number 10. The application may be heard on a motion roll. Right. Request to have a matter re-enrolled. Number 1. A decision to remove the matter from the roll must be sent to the parties within 14 days of the date of the hearing. 2, if the referring party who was absent from the arbitration hearing wishes to have the matter re-enrolled, that party must submit a request for re-enrollment to the commission within 14 days of the referring party becoming aware that the matter has been removed from the roll. The request for the re-enrollment must be served on the other party. Upon receipt of the request for re-enrollment, the other party has 7 days from the date of receipt to file opposing papers. Number 3, the commissioner considering the request for re-enrollment may decide whether the matter should be re-enrolled based on the submissions received from the parties. Number 4, the commissioner considering the request must issue a decision within 14 days from the receipt of the answer from the other party or upon expiry of 7 days of the commission and 7 days, and the commission must inform the parties of the decision. Number 5, if a situation for which these rules do not provide arises in proceedings or contemplated proceedings, the commissioner or the commission may adopt any procedure that commissioner or commission deems appropriate in the circumstances. 32, how to apply to vary or rescind arbitration award or rulings. Number 1, an application for the variation or rescission of an arbitration award or ruling must be made within 14 days of the date on which the applicant became aware of the arbitration award or ruling. Number 2, this rule does not apply to a decision taken by the commission or commissioner to remove the matter from the case roll in terms of rule date. 33, how to apply to refer a dismissal dispute to the labor court. That's interesting. 1, an application in terms of section 191 subsection 6 of the act to refer a matter to the labor court must be delivered A, within 90 days of a certificate that the dispute has not been resolved being issued, or B, by a party that has not requested arbitration within 14 days of the referral for arbitration being filed. 2, despite sub-rule 1, a party that requests arbitration may not thereafter make an application in terms of section 191 subsection 6 of the act. Number 3, the application must state the grounds on which a party relies in requesting that the dispute be referred to the labor court. Number 4, if any party to the dispute objects to the matter being referred to the labor court, that party must state the grounds for the objection within 7 days of receipt of the application. Number 5, the commission must notify the parties of its decision in terms of section 191 subsection 8 of the act within 14 days of receiving the objection. Number 6, in the event that the request has been granted, the party who applied for referral by the director must refer the matter to the labor court in line with Rule 11 of the rules for the conduct of proceedings in the labor court. Okay guys, that was part 6 of the new CCMA rules. In the next video then we'll deal with part 7. Thank you very much guys for staying tuned to the video. Please guys, I encourage others to join the channel, to subscribe to the channel, like and comment. Thank you very much guys, highly appreciated. See you.